Adam is the General Manager of Western Australia and South Australia Enforcement at the Australian Competition and Consumer Commission. He has been with the ACCC since 2008 and is part of the ACCC Senior Management Team and heads the ACCC's enforcement operations in Western Australia and South Australia. Adam, I'd like to welcome you to the stage.
Thank you very much, and I'd like to thank you for the invite to come and to speak to everyone today. Certainly a great opportunity on a very important topic. I might start by just getting a show of hands as to who's familiar with the Australian Competition and Consumer Commission, or the ACCC as we're often called by short. You just want to put up your hands in relation to that? Oh, good number of you familiar with us. Anyone ever made a complaint to the ACCC or had any engagements with the ACCC? A few less from that perspective. Good. Okay, well what I wanted to do today was spend just a little bit of time giving you an indication of what it is, who we are and what it is the ACCC does. And also, and importantly I think, is that the role that complaints play in our work and how important it is to and fundamental to the work of the ACCC. As introduced, I won't spend any particular amount of time focusing on aged care complaints or anything of that nature. Just to give you a bit more general, we cover a very wide range of industries and functions, so I'll give you a bit more of a general flavour from that perspective. Now, so the ACCC is an independent Commonwealth authority and it's Australia's competition and consumer regulator. The ACCC promotes competition and fair trading and also regulates national infrastructure to make markets work for everyone. What I wanted to focus on today though was primarily the roles we have in protecting consumers and ensuring fair markets by enforcing the Competition and Consumer Act and the important role that complaints play in that process. In performing its role, the ACCC receives a wide number of complaints, and I'll go into a bit about the detail of those shortly. That information comes from a wide variety of sources, but in particular the information that comes from consumers and businesses really helps the ACCC to understand what's causing most harm to consumers, and therefore we're best that we can make an impact by focusing our resources in those particular areas. The Australian consumer law is a national law, and it forms part of the Competition and Consumer Act that I mentioned before. It's a single national law that aims to protect consumers and ensure fair trading in Australia. It's administered by both at a national level, the Australian Competition and Consumer Commission, but also at state level by the various consumer protection bodies. The Australian Consumer Law, or the ACL we call it, in brief, provides for a number of protections for consumers. I don't want to go through those in too much detail because I know that you will have all had a nice lunch and consumer law might not be the most exciting thing directly after that. But what I wanted to touch on was just a couple of the main provisions and protections that the Australian consumer law provides. It prohibits businesses from engaging in misleading or deceptive and unconscionable conduct. It guarantees certain consumer rights when buying goods and services. It includes unfair contract terms laws for standard form consumer contracts, and it also includes unsolicited consumer agreement laws for door-to-door and telephone sales. And I'll spend a bit of time just touching on each of those. There's a number of other provisions included, but I thought I'd pick on those four because they are key ones that really do impact on a day-to-day basis, and ones that we primarily receive a high number of complaints about. So under the Australian consumer law, claims made by businesses, or businesses can legitimately make various claims as long as they are not misleading and that those claims can be substantiated. It's unlawful for a business to make statements about products and services that are misleading or deceptive. Promises, opinions and predictions can also be misleading or deceptive, and so too can saying nothing. Failing to disclose relevant or important information may in certain circumstances also be misleading. And our focus on misleading deceptive conduct here is not only to protect consumers, but it's also to protect businesses that are doing the right things. Those that, sell their products or services without engaging in that conduct are naturally at a competitive disadvantage if their competitors come along and engage in conduct or make statements or claims about their products which they can't substantiate or just simply aren't true. Under the Australian consumer law, when you buy products and services, they come with automatic guarantees. Those guarantees are mentioned on the slides. They include goods are acceptable quality, the goods match their description, the goods are fit for purpose, and services are carried out with reasonable care and skill. Essentially what all that means is when you sold something, it has to work and essentially has to do what it says it does and what you asked for. And if a business fails to deliver on that, there are certain consumer rights that cover repair, replacement or a refund, and you may also be able to cancel a service in certain circumstances, compensation for damages or loss. I think really important here, which is the last point on that slide, is that those rights can't be denied or suggested that they do not apply. Often we see businesses that promote warranties or extended warranties and failing to essentially make it clear that these statutory guarantees apply regardless of the provisions in those warranties. This is probably the key area of complaint that the ACCC gets, particularly around certain times like Christmas and things like that. We are quite literally flooded with queries about either what are a consumer's guarantee rights or a complaint about where they're not being met by a particular business. In 2016, the ACCC received approximately 20,000 complaints of this nature, so it's quite significant. The majority of those, or more than a quarter of those, relate to returning electronics and white goods. We've taken a number of companies to court in relation to this very issue. Both Harvey Norman previously, and we're currently also in court against Apple for consumer guarantee contraventions, or what we allege to be. I think this is really important in how emphasises how we use complaints. We have taken a number of businesses to court in relation to these issues, but despite that we still get a large number of complaints. And it helps the ACCC focus its resources around if these particular cases that we are taking aren't having the desired effect, what else can we do? And in this space, a really important part is educating consumers so that they know what their rights are. So at first instance, they can make the complaints to businesses and hopefully get the outcome they desire, and certainly one they deserve under the law. Unfair contracts terms is another common area of complaint we receive, and that's that essentially in standard form contracts, and those are ones that are offered on a take or leave basis. We see them a lot in energy and telecommunications, where here's the contract, here's the terms, sign at the bottom line. That's a standard form contract. Those types of contracts can't include terms which are considered to be unfair. Up there is really the definition of what an unfair term might look like. It's one that would cause significant imbalance to the parties' rights and obligations arising under a contract. It's not reasonably necessary to protect the legitimate interests of the party that would be advantaged by that term, and it would cause detriment to a party if it was relied on. What is possible in those circumstances is that a court can declare that that particular term is unfair and therefore can't be relied on. And finally, I just wanted to also touch on unsolicited consumer agreements and the laws around that. These, you'd probably be familiar with these types of agreements. That are things that you might get called up about to enter into, or someone comes and knocks on your door and tries to sell you something. We see it frequently in telecommunications and also energy. And there's quite prescriptive laws around what is required in that transaction, and it can only be engaged in certain times, and those times I've highlighted up there. But importantly, if someone's to ring you up or come to the door, the seller, that person must disclose who they are and what they are there for. They must make it clear that if they're asked to leave, they will do so immediately. And they also must provide cooling off rights. So if you enter into an agreement at that stage, you then have the option to exit that agreement without charge for the next 7 or 10 days. So they're just some of the rough, or some of the few and important protections that consumers have under the Australian consumer law. I wanted to spend now just a little bit of time on what the ACCC does with the range of complaints that it receives. And you will see that up there it gives you an indication, or a size at least, of the number of complaints that we get. In 2014-15 financial year, we received 260,000 complaints, and 2015-16 that's increased to 340,000. They're not all complaints. Sometimes they're inquiries or requests for information. But for an organisation with about 750 staff, it's quite a workload to manage. We get complaints from members of the public, the media. Staff can raise concerns with issues that they may have seen in the market, and also referrals from other agencies when they think that ACCC might be the best body to take something forward. We also get a lot of complaints, since not up there, from businesses about what their competitors and the types of conduct that they might be engaging in to get an unfair advantage. These complaints come through the ACCC's Info Centre, which is our first port of call, which essentially logs all the complaints and records all those complaints. And then a determination is made as to what to do from that with those complaints that we receive. I think it's important to mention that, as I mentioned, the size of the organisation, we've got limited resources. It's important to mention that the ACCC is not a complaints handling body. We don't look to address every single complaint that we receive, and we don't act for individual consumers or businesses or give them specific legal advice. We just can't possibly do that with the resources that we have. But all complaints are carefully considered, and what, in absolute terms, it gives us is a real indication of the types of issues that consumers and businesses are experiencing, and any harm to the competitive process or consumer protection that might flow from those complaints and what they indicate. We allocate our investigative resources to those matters that will provide the greatest overall benefit to businesses and consumers. Up there is the ACCC's competition and compliance policy that's issued each year, and what it essentially does is that it outlines both the principles we adopt to undertake our function, and also our enforcement powers, priorities, the strategies that we would plan to adopt over the coming year. With all the complaints that we receive, while we can't pursue them, they're of fundamental importance to the ACCC in pulling together this document, which really shapes our work ahead for a year. Those areas there are what are articulated in that document. We have certain priorities that we want to focus on each year, informed by all kinds of information that's provided in advance of that document being pulled together, but also based on the complaints that we've received. So there you've got some of the priorities for 2017. I haven't listed all of them, but some of them are consumer issues in private health insurance, consumer guarantee concerns in new car retailing and airlines, internet speed and performance claims, consumer issues in commission-based sales business models, and also the excessive payment surcharge laws and compliance with those laws. So we'll have particular areas that we want to focus on, but then above that is the priority factors, and that essentially means that regardless of what the conduct is that's being complained of, if it touches on one of these priority factors like a significant public interest or concern, substantial consumer or small business detriment, involves essential goods or services or affects vulnerable or disadvantaged consumer groups, then those are the types of things that the ACCC will really focus its attentions on. What I wanted to go through now is just a couple of examples of action we have taken. I've focused on these, one because some of them you may be aware of, but generally because these are things that came to the ACCC as a result of complaints. The first one, and probably the one you might most be familiar with, was our action in relation to Coles and their advertising of bread as freshly baked in store and baked today, sold today, when actually the loaves have been pre-baked in Ireland, often, frozen and then sent to Australia and finished off in the bakeries in Coles. Coles was, in this instance, found to have engaged in misleading conduct, and as the judge pointed out in that particular matter, it's important that sellers in the market recognise that consumers are entitled to reliable, truthful and accurate information, and in this case obviously it wasn't considered to be the case. The ACCC here took action not only because of the impact on consumers, but also importantly the impact on independent owned and franchised bakeries that did take the time and effort and expense of baking from scratch each day. And we felt that consumers needed to be aware of the products they were buying so that they could make informed choices. What's important here, and what's important in everything we do, is that it's not just about the ACCC action to stop the conduct of one particular business. Matters like this get a lot of press coverage and they're on the front pages quite often, and what it does is that it's not only a deterrence to Coles, but it provides information to consumers as to what they can expect, but also to other businesses as the types of conduct that they shouldn't be engaging in. And that can be extrapolated beyond bread in this case to other misleading conduct that you might want to draw parallels to. The $2.5 million penalty that Coles had to pay for this conduct is also a pretty significant deterrence to businesses not to engage in this type of conduct. Here we have a couple of examples of infringement notices that the ACCC has issued. In 2015, Voitech paid an infringement notice for representing to Lifestyle SA retirement village residents that they had to use Voitech for their telephone and internet services when this wasn't the case. Voitech had just become the preferred supplier in these in this particular retirement village, but there was no requirement for everyone to then sign up to Voitech as was being suggested, and we took action here because it really prevented the residents from considering what their alternative options might be and getting a better deal. And again, it came to us through a complaint from a competitor and consumers that felt they were being forced into something that they didn't think they should. But the other example is Clues Holding suggesting that the Seniors Plus breads that they were sold were approved by the Therapeutic Goods Administration when this was not the case. And this is important because often people will pay a premium for those kinds of features that might be in a product, and those credence claims need to be accurate. Finally, just ones I wanted to touch on some of the action on door-to-door sales, and look, this really highlights the power of complaints in my view. Both of these matters came to the ACCC because of complaints that had been received about conduct that had occurred in people's homes and at their doors, and areas where arguably they need to be protected against certain types of conduct. In the Lux example, it was unconscionable conduct towards 3 elderly consumers where they were cold called about a free maintenance check in relation to their vacuum cleaners, and then when that person came out for a maintenance check, using very high pressure sales techniques to essentially convince these elderly consumers to purchase vacuum cleaners that were quite often upwards of $2,000. In door-to-door sales, in relation to energy, and we've taken action on a number of those, but I've pointed out AGL and neighbourhood energy there. Those requirements that I mentioned before about letting known the true purpose and having to leave when requested, AGL and neighbourhood energy failed to do that at that door and instead used misleading statements that they weren't there to sell them anything, and then and several weeks later the consumer realised that they'd signed up to a different contract with a different company. Now, what's really important about this, I think, is that the law changed several years ago around door-to-door sales where these specific protections came into place, and it became known and the law changes were made because of the types of conduct that we've been engaged in at the door. Without that level of complaints and without raising that level of awareness, it's arguable that that may not have happened, and really poor practices like the ones I've just outlined there would have been continued. So it really emphasises the importance of speaking up when something is wrong. Just a couple of things I wanted to touch on to conclude. And look, I don't suggest that I've got any particular wisdom in relation to this or specific experience that the ACCC has, and some of this stuff will no doubt be common sense, and perhaps more people in the room will be able to speak more interestingly on it than what I can. But here's a couple of good tips that I was reflecting on in terms of businesses and how they can avoid complaints. I've mentioned there, obviously, practice good customer service, probably goes without saying. Know your legal obligations and don't engage in the types of conduct that we've been through today, like misleading or unconscionable sales practices, denying consumer their guarantee rights, and don't use unfair contract terms. So really understanding the law in relation to this is important so that you don't engage in those kind of activities. And also, when you do receive complaints, respond appropriately to those. The number of complaints that the ACCC gets is significant, and but we know that they're the only tip of the iceberg, and often when things come to us, a lot has to have happened before that for it to escalate to that level. Usually businesses have had plenty of opportunity to either avoid or resolve the complaints that we receive before they come to our attention. So it points to providing really good customer service as a way of avoiding those. Complaints can really be the best way to improve services. Ignoring complaints or responding to them poorly is generally pretty unwise. And when a matter does come to our attention, the damage to a business that can be caused by the poor conduct is generally significantly outweighed by the process that then needs to get going through to rectify that particular issue. I think when businesses exceed expectations, and I think that everyone can sort of sit back and think of an example of that, and the positive feeling it generally leaves you with when someone might have done that, or you're provided with something that you hadn't actually quite expected, and the word of mouth that then spreads, and that the stories that you might tell to your friends about that. In this day of social media, I think that that's only becoming increasingly important. When the ACCC looks at a matter, the first thing we do is ask the complainant, have you actually raised this with the trader? And if that hasn't, we won't look at it any further. If that has the case, and it's a matter that we do need to investigate further, we will always look at a business's approach to addressing complaints, and whether they've had a series of complaints raised against them, what our records show in relation to that, so we can work out what kind of enforcement action is actually required to correct the situation. In terms of making complaints, there's just a couple of points I would make. Is obviously don't be concerned to raise those issues, or don't be afraid to raise those issues. Always discuss it with the business first. Important to know your rights, and also consider your alternative complaint options if you don't get what you're seeking. The ACCC provides a range of resources in relation to this on their websites, and what we do have is template letters that you can use that outline exactly what it is that you might want to include a complaint. So if you have got some queries, I'd encourage you to have a look. You may also want to consider what your next options are, whether it's a complaint to the ACCC, an ombudsman that might exist in relation to the services you're looking at, Aged Care Complaints Commissioner, of course, if that's appropriate, or also the state-based consumer protection agencies will quite often will look at matters as well. So just finally, there's some information about the ACCC, our info centre, if you ever want to contact that, and also complaints can be raised through the ACCC's website, www.accc.gov.au. I think I'm now getting the hurry up, so I will exit the stage, but thanks again for your attention, and I'll happily answer any questions once Joan's spoken. Thank you.